So we are fine. Yeah, I'll give you a text today. Yes. But no, I'm not doing this. Child, we need to do this. Okay, so
from Charlie, Mamun. Ibu, sifon. Owa, sifon.
Honorable.
For us in the minority, until the substantive matter is determined conclusively, we remain determined that even on the balance of weighing monetary considerations against the weight of a constitutional breach, the emphasis should be on what harm we are doing to the 1992 Constitution and the three co-equal organs of state. So in the determination of whether some irreparable damage or hardship will be caused, our hardship as we understand it is the disrespect to the Constitution by the action of passage into law of an Act 1075 with numbers below the minimum constitutional threshold of 138 members of parliament. Can you imagine? I heard the Attorney General laboriously arguing that it was a voice vote. So Ebenezer Kum voted with his voice from an ambulance, or he voted with his voice from a clinic to add to the voice vote, and he is insisting that 266 members of parliament participated in the decision and participated in the motion. 266 members of parliament, after the minority of 136 walked out. Certainly, these are matters that the Ghanaian public can judge better. But what is refreshing and heartwarming today is the second part of the ruling, which gives directives to the Ghana Revenue Authority to preserve and keep the money. At least some people will not be in a right to collateralize it until the substantive matter is determined. For us, we raise this matter because it's of public interest significance, it's of constitutional significance, and we think that we'll pursue it to its logical conclusion. So we are very happy with the performance of our lawyers. We only pray that Ghana is not going to have two sets of laws. One that serves and protects the elected elite of a ruling government, and ones that serve the political minority of an opposition. Judicial notice of our walkout, they walked out when the budget was rejected. You know the numbers. It was 274. We're not told that quorum for decision was 274, as we have been told somewhere in someone's argument, at least not the court, that 266 passed the motion. What you people should note is that in parliamentary practice, the fact that you took a motion through second reading did not mean that at consideration and third reading, you didn't require minimum numbers. We still uphold the principle. At least the situation was marked absent from the record that we have. God bless. Thank you.
Very satisfied and fully content with the outcome today. And I think that for me, that underscores the point that do not go to court based on conjectures. I actually heard the court use that expression in relation to one of the contentions of the applicant. Yes, you found before the court a bundle of speculations as to even the numbers based on which Parliament voted to approve E-Levy. And I feel that was way below the standard. Yes, I mean, the applicants themselves were not even certain as to what number approved the E-Levy bill, if you may say. And for me, that's very material, because the current composition of Parliament now even the absence or presence of one member of parliament makes a lot of difference. And so you cannot go to court and say that either 136 or 137 members of parliament approved it and all. That's very material, especially in light of my contention that the present composition of parliament, the fact that there are only 274 validly elected members of parliament, and the fact that the election of one member of parliament has been cancelled, reduces the quorum. The quorum for taking a decision now is 137. And therefore, if the applicants themselves contend that perhaps 137 members of parliament approved the E-Levy bill, for me, is actually goes to buttress my point that yes, the E-Levy bill was validly approved. And of course, we also heard the court say that there was nothing irregular on the face of all the documents tendered by the applicants. And those documents were documents that showed what transpired in Parliament. And so if you go to court and there's no evidence of irregularity about the proceedings of Parliament, then in my view, you have not even satisfied the basic test for the grant of an injunction. So that's it. So I'm fully satisfied with it.
Do you think this is a prelude to, even though we've not gone into the substantive case, do you think this shows an indication that probably this is going to suffer the same fate as a substantive case?
Well, I only want to prejudice the outcome, safe to say that, yes, there is no evidence that can be manufactured. The evidence that was considered by the court is a record of Parliament. The record of Parliament is what we have tendered, proceedings of the 29th March 2022 that show that a minimum of 266 members of Parliament participated in the approval process for the E-Levy bill, which of course later on became the E-Levy Act at 1075. So that's formed part of the laws of Ghana. So I think that yes, we will go by the record, and I'm sure that upon a proper consideration of what transpired in Parliament, the court will find nothing to vitiate the proceedings on the day in question.
No, is this not the same record that the applicant also filed? How come we're having different angles to it?
Well, it's their construction, and the construction clearly that they sought to place on it was erroneous. I think they underestimated the burden that's on them. The burden on them is in accordance with evidence out to the country. It's the person who propounds a certain position who has a burden to prove. And therefore, if you want to prevent the enforcement of a law duly passed by the Parliament of Ghana, then you ought to show that there was something irregular by proceedings. But you just thought that by merely indicating that there's a walkout will satisfy the standard. You ought to show when the walkout took place. You also ought to show how many members of Parliament engaged in the walkout. And the record of Parliament did not show anything at all. And that's what they sought to rely on. And I'm therefore not surprised that the application was dismissed.
In terms for the ordinary Ghanaian from the legal side, what does this mean for the implementation of the E-Levy, this decision of the court?
Right. So you see, clearly it indicates that there's nothing inhibiting the execution of the law. There's nothing impeding Ghana Revenue Authority from collecting the revenue. And of course, they're also free to apply the revenue to developmental activities of the government. The government is free to apply the revenue, of course, in accordance with the promises that has made to the people of Ghana. And that is all. The only duty is, as the court stated, to keep records. And keeping records is just as they've been doing all the time. So it's just an affirmation or a restatement of their statutory duties. So nothing has changed. The E-Levy law is being implemented.
All right,